Okay, guys, we will start the session. So, we will go for a quick recap of what all things you need to cover in this session, like in polity when you go for the exam. Okay, so what I'll do, I'll divide this into 4 sessions. Today, I'll take 2 sessions. Like right now, I take one session for maybe 1 hour, and then I need a break because I have a meeting, and then we will meet maybe after 30 minutes. Okay, and then I'll take 45 minutes also. Then we will cover some substantial portion like this preamble, fundamental right, fundamental duty, DPSP, president, vice president. All these I'll try to cover. But guys, I will not be discussing in detail of all these. What we can expect in exam and what we need to go through in detail. So when I say something like the articles which is connected to federalism, then we will refer to those articles like whether it is quasi federal or is it unitary bias. So we will be discussing about all these articles. Based on that also they can ask you prelims question. So I may refer to like article 249. I'll briefly discuss here, but you may not get any time to write it down, or just note down this article and then you need to refer it. Some of you have already done with these sessions, so it will be a good revision for all of you. Okay, so this is what I'm planning to do, and tomorrow we will discuss about, so what we generally do. This is what we need to cover. First we will not first, this is something which we need to cover: legislature. So parliament we will cover in detail, and then executive. In fact, when we discuss in the Indian context, executive is actually part of legislature, right? So legislature and executive. So executive is actually derived from the legislature. Executive means the council of ministers, the ministers. So when we say executive, these are the people who implement the law. Okay, legislature, they make the law. So legislature make the law, executive implement the law. So legislature include all the MPs. What is this in Indian context? If you see, this include the Lok Sabha and Rajya Sabha. Okay, so Lok Sabha and Rajya Sabha, all the MPs will come together, or all the MPs will come here, and some of them will be the ministers. So that is what part of executive. Okay, so in fact, you can say executive is part of legislature. If you see presidential system, it will be different. This is executive, so which is headed by the president, legislature, and then judiciary. If you look into the system that we follow, so executive is derived from the legislature, and then we have the separate independent judiciary for enforcing these laws. So legislature make the law, executive implement the law, judiciary enforce the law. Okay, and judiciary have some other functions also, whether the laws are made in a correct way, like these concepts like due process of law, procedure established by law, everything we will quickly look into. Okay, so but if you look into this system, executive separate, they will implement the law, legislature make the law, judiciary enforce the law. Guys, if you look into our system here, if executive want a particular law, they can actually come up with that law, they can legislate that law. Why? Because they are the ministers, because they enjoy the majority. Okay, so once you enjoy the majority in the parliament or in the legislature, it is easy for you to come up with a law. But that may not be the case with this system. Even the executive want a law, but they can only ask the legislature to pass it. But if they don't pass it, they have nothing to do. In fact, this happened even with this Barack Obama case also. During that time also, with respect to some license to possess arms, something like that, there was a case and the legislature was not ready to follow Barack Obama. So that was a difficult situation. In fact, it is like a threat to democracy also. Okay, but in Indian context it is different. If executive want to do something, and provided if it is not a coalition government, if the executive is actually enjoying the majority, and if you see the current setup and everything, they enjoy the majority, so it is easy to make the law. Okay, so in fact you can say some of the time the laws are in fact made with the wish of the executive only. If they wish to do, they can do it. Okay, so this is a part: executive, then legislature, and then judiciary. So this is what we need to cover. So we follow the parliamentary system. This is how the parliamentary system. and this is the presidential system. Three are separate, three organs. There is a clear cut separation of power. You can see this is what, guys, separation of power. Why the separation of power is required? There won't be any arbitrary action. Okay, so the powers of each organs to be limited. Otherwise, what will happen? The state can go with arbitrary action. The executive actions will not be checked. So to check executive action, there is a judiciary. Okay, but here in American system, there is a clear cut deep division of power. Everything is separated: executive role and the legislative role and the judicial role, all are separated. But here also you will see separation of power, but not this level. So this is the concept of separation of power. Okay, now this ministers will be MPs. Okay, so if they are not MPs, they have to be get it elected after before 6 months that they became the minister. Otherwise they cannot continue as minister. And this MPs can be from, the ministers can be from Rajya Sabha as well as Lok Sabha. So the ministers are basically selected or chosen from these MPs only. So the members of parliament, right? So these legislatures are automatically the members of parliament. So they make the laws. The ministers, which include these MPs only, from that MPs itself, they implement the law. So legislature, executive, and judiciary. Okay, now what about the strength of this 545 when we discuss about Lok Sabha and when we discuss about Rajya Sabha? 245. Out of this, how much directly elected? 543, and 2 are nominated directly by the president from Anglo Indians. Okay, when it comes to this one, it is 233 elected, and then 12 are nominated. Okay, but this nomination, it is actually given in constitution. They are having some special knowledge. So these days you will see the trend of asking these very specific question: which among the following, which is given in the constitution? What are that? Art, okay, literature, science, and then social science. So this is what actually given in the constitution. But if you look into Sachin's case, right, so in that it has been made clear that any expert, okay, can become a member of Rajya Sabha. So even though this is mentioned, this is specified, but any expert who have a special knowledge, so if you find that option, that you can go with that. Okay, any expert can be a member of Rajya Sabha. He can be nominated. So that is also something which you need to keep in mind. Now, what do you mean by the political executive or temporary executive? When we talk about the ministers, so executives are of two types, right? As of now, I have briefly discussed about executive. There are of two types: temporary and then permanent. What is this temporary executive? These are the political executive. Okay, who are these permanent executive? These are the bureaucrats. So this temporary executives are the ministers. They will be for specified time, right? Like 5 years or whatever it is. Why they're also known as political executive? Because they belong to some political party. So the political executive or temporary executive, they are the ministers. They are for some time, specific time. Why this is known as permanent? Because they will be there till retirement. Okay, so bureaucrats, they are the permanent executive. So there is here there is a fixed tenure, but this is up till the retirement. So this one also we will see. Okay, so now what do you mean by constitutionalism? This term, guys, constitutionalism means it's all about rule of law. To what extent you are able to follow rule of law. So if you see, there is actually none of the country who's 100% you can say constitutionalism is at the peak or 100%. It should be understood in terms of continuum. Like there are some countries, even though there is a constitution or anything, but still you can say sometimes zero constitutionalism, or you can see 100% constitutionalism. But some countries like India and all, it will be in between. But when we see the word constitutionalism, it's all about rule of law. But there are certain conditions. So if you look into the questions that can be formed, which among the following are important for constitutionalism or important parameter for understanding the constitutionalism, what is that first and most important one? It is rule of law. So rule of law means, I've told you many times, it is the system of lex rex. Lex rex means law is supreme instead of rex lex. Earlier the king supreme, so king is law. This is the setup of king is law. So king is the law to law is the king. In fact, if you see in all the courts, you will see the statement, law is king of kings, with whose aid even the poorest will be able to win over the mighty, or even the poorest also able to get justice over the mighty. So that is what you mean by rule of law or lex rex. Law is king. That is the most important point when it comes to constitutionalism. Apart from that, you can talk about democracy, democratically formed constitution, democratical setup. Okay, separation of power is very important for ensuring constitutionalism. If separation of power is not there, what will happen? There will be arbitrary use of power. So there has to be some checks and balances. Okay, so you can also talk about checks and balances, various checks and balances. And who is actually ensuring this? The citizens are not subjected to arbitrary use of power or arbitrary executive action. Who will be supporting? It is the judiciary. So judiciary is also considered very essential when it comes to constitutionalism. Then this fundamental rights. Okay, and these are the essential components of constitutionalism. So I hope you got this idea of constitutionalism. In case if there is a definitional aspect or one line or any question, if you see, you should be in a position to get this. But the main point is rule of law. Okay, according to Dicey, what is actually rule of law? Rule of law means state cannot take any action against you unless and until you violate a law. So you can only be punished. How? There is only one way. Nobody in the world can punish you. Okay, nobody in India or nobody in the world can punish you. So punishment can be given in what situation? Only and only if you violate a law. Okay, now whether you violated a law or not, who will be telling this? Can a complainant tell to someone that you have violated a law? No, right? You cannot. The complainant cannot tell that. Complainant may give a complaint, but that doesn't mean that you will be punished. Can the police tell, and based on that you will be punished? No. Okay, then who need to tell that? It has to be proved in an ordinary court of law. Okay, so this is something which has to be there. This is what you mean by rule of law, the essential component, that nobody shall be punished, okay, except for violation of law. That means only and only if you violate a law prevailing in the land, then you will be punished. And who will decide whether you violated a law or not? It has to be proved. Only upon proved violation of law, that means, can you be arrested on the basis of assumption that you committed a offense or not? No, right? That can be done in preventive detention, but otherwise it cannot be done. So this is the key principle. And also one point that you need to know is ex post facto law is not actually applicable, right? That means when you committed something, there is a law. If it is existing, on the basis of that only you will be tried and you will be punished. Okay, later the offense or something this incident happened on this day, and the next day the law is coming into force, that doesn't mean that you will be subjected to be punished under this law. So these are key principles of rule of law. Now, who introduced rule of law in India? When we discuss about rule of law, this is something which is introduced by the Britishers, right? By Lord Cornwallis. So I hope you guys have some good knowledge about modern India. So Cornwallis Code, okay, or the judicial reforms done by Lord Cornwallis, there you will be discussing rule of law, etc. Okay, procedure established by law or rule of law. Okay, so this is very important, guys. Okay, rule of law. I hope this is clear. So we are actually discussing the concept of constitutionalism. Okay, now one more thing that you need to look into is various features of the constitution. But here I don't have time, but this is something which you should not miss. In case of exams, they can ask you questions from this area. Rather than preparing features, some of the features, at least important features like DPSP, if you see, from where it is borrowed from Irish constitution, right? Similarly, impeachment of the president, from where it is borrowed, USA. At least those important features where from where it is borrowed, like fundamental rights from where it is borrowed, fundamental duties. Okay, the parliamentary system, from where parliamentary system, that is what we have experienced, guys, right? So it is directly from UK. Election of president, Ireland. Preamble or this impeachment, USA. Okay, federal structure, that is Government of India Act 1935. But the federal setup with a strong center, that is from Canada. Okay, rule of law, obviously from UK. I've told you it was introduced by the Britishers. And remember that Governor General name also, Lord Cornwallis. Okay, so mainly we have borrowed from mostly, in fact, 60% of our constitution is from Government of India Act 1935. Whether it is this federal structure or all those things, even Supreme Court, this Public Service Commission, and everything is there. You can see that. I hope you will be going through that 1935 Government of India Act. This is very important. And in fact, anyway, when you go with this 1935 Government of India Act, 1919 Government of India Act also is very important for you. Okay, so don't be confused with the concept of this diarchy and federation. Okay, so when we discuss about diarchy, this is rule of two. Federation, this is also rule of two. So archy means rule, diarchy means rule of two, monarchy means rule of one, federation also rule of two. Okay, but in this case, rule of two at the same level. Now you can see in now 1919 Government of India Act, it is at the provincial level diarchy was introduced, right? So at the same level, at the provinces, rule of two, there is a transferred list and there is a reserve list. So the governor who is appointed by the viceroy will control the reserve list, the most important list. Okay, components will come there, like budget and law and order and all these things. On the other hand, the transferred list will be handled by the elected ministers. So these are very minor, like irrigation and all those things. Okay, so I hope you understood. No need to have any confusion. Diarchy and federation both are different. In both cases, it is rule of two. Here, rule of two means ministers on one side and governor on the other side. So two lists are there, two authorities are controlling that. But what is the difference? Rule of two at the same level. Federation means rule of two at the what does that mean? At the state level, at the center level, or you will see state or provinces. Okay, so provinces and the center. This is what rule of two. So this was introduced in the 1935 Government of India Act. Okay, so some of you will have a confusion, diarchy, and when you see federation, the word federation was introduced in 1919. No, it is diarchy. That is different. Introduced in 1935. Okay, so I'll come back to federation, but before that, let's quickly look into these. Okay, but do we need to discuss about all these features and from where it is borrowed at this juncture? No. Why? Because clearly there is no need to waste the time. It is clearly given in Lakshmikant, and you just need to spend hardly 20-30 minutes, and it has to be very clear. And even before the exam also, you need to look into that. There is a high possibility at least these concepts like fundamental duty, fundamental right, DPSP, impeachment of the president. Okay, similarly the removal of Supreme Court justice and etc., that has to be understood, and it should not be missed out. Okay, next one, objective resolution. So when it was introduced, objective resolution, I hope you have a clear knowledge about this. Objective resolution introduced on 13th of December 1946. Okay, so this resolution actually got passed on 22 Jan 1947. So what is this objective resolution? This is basically the philosophy or the idea underlying Indian constitution, which was represented in the form of this objective resolution. What is objective resolution? There is a philosophy. Like it will be like guys, there are important points that you need to remember, because that you will see it will be reflected what all things which is there in objective resolution. I've told you this is philosophy, so you will see in the constitution it will be reflected, like secularism, okay, protection of minorities, fundamental rights, all these are there in the objective resolution. This is nothing but the philosophy or idea of how the constitution should look like. Okay, so it has been presented by Pandit Jawaharlal Nehru in the first session of the Constituent Assembly. Okay, so this day it was introduced on this day and it was passed on this day. Like India will be a independent democratic sovereign republic, federal form of government, secularism, freedom of thought and expression, protection to minorities, promotion to world peace. Okay, all these are there and you can see all these are reflected in various provisions of the constitution. Now, I hope you guys have knowledge, know about what is written constitution, what is unwritten constitution. We have a written constitution, means everything is codified. Okay, so there is a body to prepare the constitution, and that body prepared the constitution, and everything is codified, and the constitution is supreme. Okay, but on the other hand, if you look into UK, these are unwritten constitution. Their constitution is like various laws which has been passed over a period of time that has been codified, where the parliament is supreme, but in Indian context it is the constitution is supreme, and there will be independent judiciary to enforce this constitution also. So it's like we don't want to discuss too much about this. Written constitution means everything is actually codified. On the other hand, it is the, and all the laws are made out of constitution, or it has to be supplementing the constitution, and any law which violate the constitution will be struck down by the judiciary as void or null and void, right? But that's not the case here. Here the laws automatically become, this constitution is actually evolved, this constitution actually enacted. Okay, evolved means even from this Magna Carta onwards, whatever orders, whatever laws which has passed, all these are incorporated, and that means who's supreme? The parliament, who's the law making body, who is actually supreme. But here the constitution is supreme. Any law which is made by parliament which is against the constitution will be struck down by the judiciary. Okay, do we need to discuss about federal form of government? So when you see federal form, the key points that you need to look into, this is the rule of two, right? Diarchy also rule of two, but understand guys, this is at two levels. That's the difference. The other one is at the same level. Two level means provincial level at the central level, or now forget about province, you can talk about state level and the center level. Okay, so this is what you mean by two levels. Secondly, it's like two forms of government exist, and here there will be a government at the state level, there will be a government at the center level. And will there be any superiority or inferiority? No, both will operate, both will be elected by the people, both will go hand in hand simultaneously. So there is no question of inferiority or superiority here. None is inferior or superior over the other. Both derive the power from where? Both derive power from constitution. Okay, and then in case of a federal setup, we definitely need a written constitution. Why we need a written constitution? Because that separation of power, where the center can influence and where the state should stand, everything has to be very clear. Otherwise, what will happen if it is not written? If nothing is codified, over a period of time, center can overlap on everything which is related to the state also. So in a federal setup, it has to be a written constitution. Okay, and also there should be an independent judiciary to enforce this. Okay, so any dispute between center and state which has to be going for directly, this is actually the original jurisdiction of Supreme Court. Okay, so any issue between center and state and between two states will go to the Supreme Court. On the other hand, if you see unitary constitution, like you can see this can be written or unwritten. It doesn't matter, right? Whether it is written or unwritten, it's okay. For example, UK, it's a unitary system, it is unwritten, and there are other countries where it is written constitution or are also there. So it can be both. Okay, so that's about federal. These are key points which you need to note down. It has to be written, otherwise it will not function properly. And there has to be an independent judiciary, like in the context of India, if you see the Supreme Court. But what about India setup? Is it truly federal? No. Is it unitary? No. It is like quasi-federal, or it is federal with unitary bias. Okay, then what all are that federal features or what all are that unitary features, maybe this can be a question for you in your mains. So we are not interested in discussing too much about that, and I'm not going to put that into perspective at this juncture. But here, if you want, we can discuss about some of the unitary features, where the like if you see all India services, similarly election commission, similarly comptroller and auditor general, all these are connected to what? All these are showing the unitary features, right? But what are the federal features? Federal features means like you need the permission of the states also when if you need to make some changes, right? Even in amendment of the constitution also, guys, you will see our constitution is rigid or flexible. In some areas it is rigid, in some areas it is flexible. If it is rigid means, like we can say some of the cases you need a special majority. I'll come to that majority part, what is simple majority, what is absolute majority, special majority, everything I'll come to that. In when you say rigid means, if you need to make an amendment, you need a special majority, you need the permission of the states, etc. There are certain areas where if you need to make any amendments or changes, you need that, it is rigid, right? You need the permission of the states. What are they? Like election of the president, etc., right? Similarly, with respect to Article 73, Article 162, if you need to make any changes, like extent of executive powers of union and the powers of state, if you need to interfere, there has to be a permission, and it also need to be passed by the state legislature. Similarly, with respect to Article 241, which is related to high courts in union territories also. So if you need to make any change, otherwise there are many other areas also. Mainly there are 5 areas, guys. First one is connected to okay, now you just note it down. You can just note down these important articles. There are 5 areas which require approval of the state. Okay, Article 54 and 55, which is related to election of president. Okay, and then under this itself, you can also talk about Article 73, 162. This is related to the power of the union, executive power of union and executive power of state. And then Article 241, high courts in union territories. So just refer this. Okay, anyway, when I discuss about legislature, and this I'll discuss when it comes to the president, this I'll discuss when it comes to the parliament. Okay, this I'll discuss when it comes to high courts. If possible, if we have time, I'll discuss. If not, you have to read this anyway. Okay, second area where you need second area is like chapter 4 of part 5. What is part 5? Part 5 is related to union. What is chapter 4? Chapter 4 is talking about judiciary. Just before I have talked about high court at the union of the union territories. Similarly, high court of union territories means it will be at the states only, guys. Okay, we will come to that, different high courts. So judiciary at the union level means I am talking about Supreme Court, right? This is the judiciary at the union level. So any changes or with respect to the operation or the power of Supreme Court, if you need to change, it has to be with the permission of the state as well. Similarly, high, not only at the union level, at the state level also, that means high court. So any changes, if you need to make the functioning or operation or the powers, jurisdiction, etc., with respect to the high courts, also you need the permission from the state. It is like chapter 5 of part 6. Okay, so similarly, this one, chapter 1 of part 2, that is the center state legislative relation. Okay, so there also, and again, the third area is related to schedule 7. I hope you know about schedule 7. These are related to the 3 list, list 1, list 2, list 3, that the union list and the state list and the concurrent list. Okay, so you will see in union list around 100 items are there, state list 61 items are there, and then concurrent list 52 items are there. So here both state concurrent list, both concurrent, right, parallel, that means state as well as union will make law. Here state list, only state will make law. Here the center will make law. Now guys, if you look into this itself, the number is very less compared to this one. The number is less here. That also you can write as a unitary bias, right? More items are actually given to the center. Similarly, fourth point is related to representation of state in parliament. Then the fifth area is related to Article 368 amendment, right? So power of parliament to amend the constitution, and the procedure is what actually given in article 368, and for that also you need the support of the state. So in these areas you will see slightly rigid because you need the permission, but there are some areas like even if you need to change the name of the state or alter the boundaries of the state, this can be something which can be done with a simple majority. That means state do not even have any power with respect to their name or their boundary also. It can be done easily with a simple majority. Okay, then with respect to this one, you can just but these are very important for mains only. At this point you just go through these lists, and guys, some of the important points of these list also, like which among the following are part of center list. Okay, that also they can ask you which among the following is part of concurrent list. Not all you need to know, something is coming in the news, something which has to be referred. Okay, so anyway, when you're going through the current affairs, vision IAS and all, they will make it very clear if it is required. But this can be asked, these questions can be asked. Now, some of the articles which is showing this unitary bias, even though we are unitary or federal, but there are some unitary bias, right? That is what I've told you, quasi federal or union of states, but a tilt towards center. Okay, article 249, this is something which you need to refer. Okay, just note it down along with me, and some of you already know that we have already attended and done with the session. So article 249, what it is actually talking about, it is talking about the Rajya Sabha can pass a resolution with, okay, no, okay, uh, guys, I'll complete this and then I'll discuss about these type of majority. Quasi-federal, that's the name which you can see. Quasi-federal means quasi-unitary also. Okay, but quasi-federal is what you need to use. That is what it is. It has been seen. Guys, all the majority I'll discuss, but even when I'm discussing about these articles like article 250, 252, etc., I may use these special majority, etc. But what is this special majority? I'll come to that. Okay. So right now, just focus on these important articles, which shows unitary bias, a tilt towards center. So here, Rajya Sabha can pass a resolution. Rajya Sabha can pass a resolution with a special majority. Special majority means, what is special majority? I will tell you right now. Just keep this point in mind. It's like 2/3 of the majority that you required at the time of voting. Whoever is present, let's suppose 100 members are present, 2/3. What is that? 66. This much is required. But at the same time, it should be more than the total. Suppose 545 is the total, right? Then what is more than 50% of the total? It has to be 273. Okay, so that is what you mean by special majority. Guys, I will come to this. No need to have confusion now, because other majorities also I'll discuss. Then I'll discuss special majority, so it will be clear. A special majority means it has to be what, 2/3. It will come along with 2/3, and also absolute majority. Okay, so if Rajya Sabha pass a resolution with special majority, then the parliament can legislate over a specified state subject. I've told you about three lists, right? Union list, state list, and concurrent list. So state list, who will make law? State will make law. But if Rajya Sabha pass a resolution with a special majority, then the parliament can legislate upon the list 2. That means the state list. Okay, so the parliament is getting the jurisdiction over the state list under article 249. This is a very important article. It can be asked in prelims, it can be asked in mains also. Even if it is not asked directly, if there is a question related to federation, then anyway you will be writing about this one in mains. But we are at this juncture, we are not at all focusing on mains, guys. We are focusing on the prelims point of view also. It is very important. Okay, so how parliament is getting the legislative jurisdiction of the state under list 2? If Rajya Sabha passes a resolution with special majority, then parliament can legislate. In fact, parliament must legislate. Parliament will have to make law on the state subject. Okay, so then the parliament will assume the legislative jurisdiction on the specified state subject. Not all, but within this list, any specified subject, it has been told, right? So that you will make. And how long it will remain in force? It will remain in force for 1 year, and it can be renewed any number of time. But at that juncture, once it is passed, it will be remain in force for 1 year. So this article is very important, guys. 249 special majority. I'll come back. Okay, now what is this article 250? During national emergency, this is at this time of national emergency, parliament assume concurrent legislative jurisdiction over the state subject. Okay, so national emergency time, so that means what? State list is there, state can make law, center can also make law. This is concurrent, that means state can make, center can also make. But if there is a contradiction, central law will prevail. Guys, when it comes to president rule, this will not be there. Only center will make law. Okay, so there is a difference between national emergency and president rule that we will see later. But in case of national emergency, it is a concurrent power. That is what we see under Article 250. Okay, similarly, Article 252. If two or more state legislature pass a resolution, guys, if there is a common threat, or for example Naxalism, two states are getting affected with this issue, then the state machineries is not able to control this issue. Then what can be done? For example, Karnataka and Telangana, they both together pass a resolution and authorizing the parliament to legislate upon some particular subject, like maybe policing or whatever it is, which is a state subject. Okay, then parliament assume the legislative jurisdiction of that state subject on these two states only, because these two states have passed the resolution. So now parliament can make a law for these two states, and this law will remain in force till the time same law is repealed by the parliament itself. Once it is done, it has to be repealed by the parliament. This I have given as an example, Naxalism. It can be anything, but once the state legislature, two of them, has passed the resolution, then it is gone out of the state. Then the parliament take the jurisdiction, parliament pass the law, then it can be repealed only by the parliament. Okay, now Article 253. This is related to international treaty. Guys, even with or without the consent of state, any international treaty, if you need to fulfill any international obligation, if you need to fulfill, parliament can pass a law on state subject with or without the consent of the state for implementation of any international treaty. Okay, so that is also, you will see a unitary bias. 356 I have already told you, right? 356 is what? When this is related to president rule. When president rule is imposed, the entire legislative assembly will be suspended, right? Automatically suspended, or it can be dissolved also. But initially, once the president rule is imposed, the council of ministers is gone. The legislative assembly may be there for some time, because you will see, is there any other possibility to form the government or not? So it will not be immediately dissolved, it will be suspended. It will be suspended means this cannot make law. So who will make law? Parliament can make law. But this is not a concurrent power, right? This is already gone, guys. Okay, national emergency, state government is there, and the center also is there. This is concurrent legislation. Here, not concurrent. This is gone. So only parliament will make law. What about 248? 248 is related to the residuary power of lawmaking that belongs to the parliament. Okay, so that is also showing that unitary bias. Then in this context, unitary bias, Article 155 also. This is related to appointment of governor. Okay, it will be done by the president, and governor will be there during the pleasure of the president. Okay, so through governor, the center will exercise the authority in the state as well. Okay, so then Article 312. 312 is related to all India services. Okay, so Rajya Sabha actually can authorize the parliament to create one or more all India services. Now, why I am discussing this under this discussion when I'm talking about this unitary bias? Why? Because all India service officers actually belong to the center, although they are working in the state. So the center can influence the state administration through the all India service officers. Okay. Similarly, there are certain other articles also, like Guys, I'm going faster because it's not like the history or anything. We have so much of things to cover. That's why I'm expecting that everything is there with you, so you can go with that reading anyway. One reading you can go with. Just note down these important articles what we are discussing. Just refer that again. Article 256 and 257. It is related to this railway properties and the means of communication. Actually, center can issue administrative direction to the state indicating the manner in which the railway properties and the means of communication shall be maintained. And if these directions which are issued under 256 and 257 is actually binding on the state, and if the state is not able to follow that, if the state is ignoring that, this can be a ground for imposition of president rule. Okay. In fact, if you remember, for those who have attended the polity session, I've told you about this one. If the state is failing to follow any administrative mechanisms or directions which is issued by the state, that is a ground for, yes, that is a ground for imposing the president rule. Similarly, secularism is also considered as a basic structure or basic feature of the constitution. So if there is any state which is violating this principle of secularism, or not promoting secularism, or doing something which is connected to religion, this can also be a ground for imposing the president rule. Okay. Similarly, other points are not that important, that you all know. Article 324, election commission. There is a common election commission for center and state. Okay, so there should be a state election commission if that is the case, right? The center election commission, which will be appointed by the center, also contesting and controlling the elections at the state level also. Guys, there is a state election commission. Okay, State Election Commission is actually after the 73rd and 74th Constitutional Amendment Act, right? That is related to the rural local self-government and urban local self-government, the Panchayat Raj institutions. But the State Election Commission is related to what? Only the election of Panchayat Raj institutions. No confusion required. State Election Commission is not the one which is conducting the election at the state level. No. Okay. State level election, the election to the Legislative Assembly or the President or the Vice President or Lok Sabha, everything is conducted by the Election Commission of India. Okay. Not the State Election Commission. Similarly, Comptroller and Auditor General, sorry. Then only one Supreme Court, right? The one and integrated, unified judiciary. Supreme Court there is no Supreme Court at the state, like what you see in case of US, right? That's not there. So these are, even though I am talking about this in the context of this particular topic, but I just want to cover all these articles also. This can be asked separately. What is Article 249? What is the relevance, like that? Which among the following is correct with respect to 249? In under which article of the Constitution the Parliament can take the legislative control over the state? All these can be a direct questions. Okay, so that is the reason why I have discussed this one at this situation. Now we'll go with preamble. Guys, there is no need to discuss this one, preamble. What I want you to know is there can be a question, but since they have asked, I think last year they have asked a question, so there may not be. But each and every word of the preamble, last year also they asked or not, I don't remember. Each and every word of preamble is very important. So this is something which you need to mug up. And there are a lot of advantage, guys, if you mug it up, because in case if you get any question in essay also, there are good possibilities that you can start with preamble also. Okay, at least some of the contents from preamble that you can write as your introduction. So that will give a value addition. So just mug it up, at least those important points. Okay, what is preamble? It is actually the summary. So, and in case of any ambiguity in interpreting any law or any provisions of the Constitution, the Supreme Court will refer to what? Preamble. Okay, preamble is actually the summary. It reflects the minds of the constitutional makers. So in fact, this is the way to open that minds of the constitutional makers actually. So if there is any discrepancy or any ambiguity in interpreting any of the articles of the Constitution, then you just look into preamble, and based on that, if any articles or any laws which is made by the Parliament, if it is for the satisfaction of any of the words which is whether if it is for socialism or anything secularism, then it has to be upheld, right? It will be like that. So any, for example, these two articles are very important, 39b and 39c. You will see this later also. These articles are very important when it comes to DPSP also, although we don't have enough time to discuss, but very important articles. What are they? Especially this one: material resources of society should reach to all. But how you can do it? And uh, guys, there was right to property and all, which was a fundamental right, but because of this directive principles, okay, like material resources of society should reach to all, that is the reason why you can go with this land ceiling, nationalization of banks, zamindari abolition and everything. Otherwise these banks were someone's property, how can you nationalize it, right? Because of this article, and we will see when some of the directive principles are implemented, especially this one, some of the fundamental rights will go. Okay, so we'll come to that later once we discuss about DPSP, but not in detail. You have to read that. Everything is clearly mentioned in Lakshmikant, but you need to have a very good knowledge about this. Okay. Now, preamble, can it be enforced? It cannot be enforced, right? And it is not actually conferring any substantive powers to any of the organs of the government, or it also not limiting any power of the government or any organs. Okay, so it is like a customary, it is not compulsory. From where we have borrowed this is from the US Constitution, Keshwanand Bharati judgment. Yes, Keshwanand Bharati judgment, that is important. Keshwanand is actually important by saying that preamble is part of the constitution mainly. Okay, in fact, what is the traditional view? Traditional view is actually related to guys. Preamble is not. What is that case? Beruberi Union case, right? Beruberi Union case. Yeah, Beruberi. Recently died. Okay, so in this case, it has been held that this is not part of the constitution, right? And it cannot be amended, something like that. But in Keshwan, the case, it has been held that it is part of the constitution and it can be amended. Why? Since it is part of the constitution can be amended under 368. So preamble can also be amended, and that is the reason why preamble you can amend. And what is that amendment? Where you have added certain provisions of the like secular and all these things were added after the amendment, right? Which amendment? 42nd amendment. 42nd amendment. Okay, now one more thing. This is actually subordinate to the constitution. Okay, in case if there is any discrepancy or any contradiction between any of the articles uh, and then preamble, then that articles will prevail. That is also something which is very important. What is the purpose? Purpose is basically it shows the philosophy, and from where the there is one more case, guys. This one, Keher Singh versus Union of India. Okay, so actually, what is the source? It is the we the people, right? That has been challenged by this guy. So we the people means we are not there when the preamble was there, when the constitution was enacted. So can we say now we the people? No, right? So Supreme Court has been clarified that don't contest this one. This is actually a legal fiction. So that is actually the conclusion under this Keher Singh. You cannot contest this we the people that thing in any court of law. Okay, so it cannot be challenged or it cannot be questioned in any court of law. So what are the ideals and aspirations? This so preamble shows the ideals and aspirations. When I say ideals, these are secular, democratic, sovereign, socialist, republic. Guys, all the meaning of the each and every term need to be known to you clearly. They will ask you what you mean by sovereign, what you mean by socialist. Everything you can read from Lakshmikant, and you need to what do you mean by republic? We have an elected government, right? So not monarch. That is what it is, a republic. Okay, so yeah, elected head is there. Then what are the aspirations? justice. When we talk about justice, it involves all socio-economic, political justice, right? Even you can talk about freedom also from this perspective: political freedom, economic freedom, and social freedom. Do you remember in history discussion, I've told you about Bhagat Singh? There was an ideological rethinking when it comes to the militant nationalism during the time of Bhagat Singh. Till then, even the Congress is also only talking about political freedom. Nobody is talking about economic freedom or social freedom. Till the time exploitation of man by man is there, then that is not true freedom. So what do you mean by true freedom? It is all about true complete justice or complete freedom in social, economic, and political freedom. You overthrow the British, what you get? Political freedom. But you need economic freedom there should not be inequality, poverty. For that, what is to be done? Land reforms and everything has to be done, right? Liberty of thought, expression, yeah, equality, liberty. This is the one which is very important, guys. Okay, liberty. And then fraternity is about the brotherhood. Okay, liberty is very important, and connected to this only you have this article 21, right to life and personal liberty. Nobody can deprive you except on the grounds something which is established on the basis of law. So out of this, what is added in the 42nd Amendment Act? This one: socialism, right? Socialism, secularism, and one more was there. Hmm. Yeah, integrity. That is not discussed here. You will see that in the preamble. When you read that, you will see that. Okay, so these are the three words which has been added: secular, socialist, and integrity, which was added in the 42nd Amendment Act, right, 1976. So three cases related to this is mainly: one is Kehar Singh. I've told you, Supreme Court have clarified that don't challenge this. This we the people or the source of power is from the people. You cannot challenge that. It is a legal fiction. So that case is now well settled. Okay, there is no dispute which is going to arise out of that. Then the question was related to whether this is part of the constitution or not. Beriberi Union case, it has been held that it is not part of constitution. Then in the Keshwanand case, it has been held that it is a part of constitution. Just like any other part of the constitution, it can also be amended. Why, guys? Why constitution need to be amended? Constitution need to be amended because constitution is an organic document. This has to be living document, right? It has to serve the purpose of people all the time. Okay, it has to be dynamic, it has to be living, it has to be organic, it should be evolving, because the time is fast changing, and the life of people and everything is actually changing. So constitution also should be a living document to incorporate the aspirations and ideals of people. So amendment is very much required. So preamble also need to be amended because preamble shows the philosophy of the constitution. So to keep it updated with the changing aspirations, we need to amend the constitution. Okay, having said that, what we will do now is, as I've told you, I'll take a break. This is 8 o'clock now. Guys, we will resume at 8:30. Okay, we will resume at 8:30 and we may go till 9:15. Very short session I'll go for. So take a break because I have a meeting now, and then we will see at 8:30. Okay, guys?